Hello, welcome back. This is Roger Royce, host of the 10,000 Startups podcast. I am a corporate and tax partner with Haynes and Boone in downtown Palo Alto, and I am also the host of this podcast where every week we bring you new original content on an issue of interest to a startup entrepreneur dealing with the legal issues that startups, and in today's case, that almost anybody will probably have to deal with in their lifetime, any business anyway. We're going to talk about alternative dispute resolution. And we have the Honorable Robert Foyles with us today. He's been at JAMS after nearly 27 years on the San Mateo County Superior Court. He is a two-time presiding judge, a prior settlement judge. He has vast experience, including civil and complex litigation, probate, and family law. So I want to thank you for being here, Judge, to talk to us about alternative dispute resolution.
Thank you, Roger. It's a pleasure to be here.
So maybe we could start, if you could tell us just what is that as a definition? What do we mean when we say ADR or alternative? Does that mean arbitration?
Not necessarily. ADR is just, it stands for alternative dispute resolution. So it's an alternative to going to court. And there are a number of ways one can go to a form of alternative dispute resolution before they come to court. Arbitration is one mechanism, and so is mediation.
Okay, gotcha. So it's something that's just an alternative to the court system. Why might somebody want to do that if they have a business dispute?
Well, I would say that in the last 40 years, it's harder to get through court. It's court funding has been limited during the Great Recession and the pandemic. Courts are overwhelmed with cases. There's criminal cases that trump the civil cases that mean they have preference. So a lot of civil litigators are finding that it now takes a lot longer to get through the court system. And because of that, alternative dispute resolution has blossomed. I'd say in the last 25 years, I was on the bench for 27. I watched the whole explosion of ADR companies, such as JAMS, and other companies like them blossom with mediation and arbitration.
Okay. So I guess it's like having your own private, settlement rather than having to be at the mercy of the public system. Now, you used an interesting word there, mediation, and I know sometimes people get these two terms confused, arbitration and mediation. Can you maybe tell, first of all, do you do both? And
I
second,
do, yeah.
Okay. What is the difference?
Well, they're really completely different animals. First, let's talk quickly about arbitration. Arbitration is a mechanism to stay out of court. As this, congestion began and continued through the courts, where it took a long time to get a case through trial and cases would get continued and it would take a while, companies started coming up with going to private judging, which would be an arbitration. And they put that in their business contracts and such that, rather than in an employment case, when an employee signs a contract of employment, they agree that if there is a dispute, that they will litigate that. Rather than going to court, they go to an arbitrator. And the benefits of that are, number one, the arbitrator, although they are paid for and they cost and they are private, they get through this process more quickly and there are no jury trials. And also the appeals process is often final, so there is no appeal. And so with all of that, it's more attractive to a lot of businesses, and it's also a quicker, faster way to get through litigation, and it may be less unpredictable because juries can be unpredictable. And it really then took off, I'd say, 25 years ago, where the arbitration clauses started to show up in contracts. And the California courts were suspicious and didn't really like arbitration contract clauses, but over the years, and the Supreme Court of the United States has approved it. So it really has become a fairly common standard where you see arbitration clauses. But the arbitration is really created by the arbitration clause in the contract. So whatever the terms are in the contract, and I'm talking like the employment contract or the or the business contract, or whatever the contract is that the person, the plaintiff and the defendant sign, the terms of the arbitration are delineated in that contract, and it's a complete circumvention of having to go to court.
Yeah.
Now, mediation, just real quick, mediation on the other side is really a process of settlement conferencing. It is if you're in the superior court, because most cases, if you're in arbitration, you would have filed in the superior court. Instead, you filed an arbitration pursuant to the contract. But normally, if it's not an arbitration, you file a case in the superior court, and you have a mandatory settlement conference with someone like me in the process of getting ready for litigation, and you try to settle the case with the judge. Mediation is a little broader concept. It's anytime you basically meet with a neutral. It's not with a judge anymore. It's with a private neutral, and you meet with that neutral and try to settle your case. You could do a mediation in the middle of an arbitration, because you're trying to settle. Or you could do a mediation while your case is in the superior court and proceeding along. It's a mechanism to meet with somebody and try to use them as an intermediary to settle your case.
I see. Okay. And I guess the other big difference is that whereas an arbitrator's ruling is binding, a mediator doesn't really have that power, right?
Exactly. A mediator is just a facilitator between the sides. All you're trying to do in mediation is work with both sides. And, you would think that maybe, two parties could just meet and work it out, but it doesn't always work like that. Sometimes people fear that if they're too conciliatory, they look weak, that, and the lawyers feel the same way. They don't want to basically talk about their strengths and weaknesses to the other side. They might be giving up too much information. So instead, the mediator, the neutral, can work with both sides. There's a lot of confidentiality that goes with that too. For instance, I always tell the parties in a mediation that if you tell me something is confidential, then I will take it to my grave. I will not convey that to the other side or anybody else, So it also is a good sounding board, because the mediator or the neutral, I call him a neutral, can kind of talk about the strengths and the weaknesses. Sometimes it helps the client also better appreciate sort of where the other side sits on this case, and the strengths and weaknesses there. And there's and a mediator would often say, this is, if you think of this as a problem, we can solve it. But if this is a war to be won, this is going to be a problem to solve. We're not going to solve it, So think of it as a problem to solve, and have a mediator try to work between the parties to solve it.
Yeah, it's interesting. Yeah, what you said about how the parties have to agree to all this. So I'm not a litigator. I'm on the business side, so I draft the contracts that hopefully, if I do my job, you'll never have to see. But oftentimes parties will have disputes no matter how well drafted.
Absolutely.
And I sometimes will put a clause requiring people to mediate. And sometimes the client will say, well, why do I want that? Can't we just agree to do that later? But I really like what you just said. It's like, yeah, but maybe you want to force this process to happen now. Maybe it's in your interest, rather than to have to come and hope that they'll come and sit down at the table later, to get them to contractually agree to it. First of all, because sometimes you can just work things out if you just get a neutral between you, oftentimes. And you might, what you just said, other times, you might not get people to want to show any weakness and agree to that later, but if they're contractually obligated. But then the second thing, and this is a little more subtle, is if there's a dispute, I want there to be a process. I want whoever's complaining about this to have to jump through hurdles, because I want this to be serious. And that kind of, and that's kind of why I might put a mediation clause in. But some lawyers have strong feelings that, gee, that you don't do that, we'll decide to mediate later.
And I don't mean to interrupt, but that's a real interesting thought, because we do the same thing in court. In court, when I was a judge, I could not order somebody to mediation. Theoretically, I can't order them. But my fellow judges and I would say, you're not getting a jury trial scheduled until you go to mediation. So the irony is, yeah, maybe we can't legally tell you to do it, but we can be about as coercive as you can imagine to get you to go to mediation 25 years ago, people didn't want to go to mediation. Yeah, they just didn't. Now it is, I would say almost 98% of the cases do go to mediation. If I have a lawyer that comes in and says, I refuse, and I'm still a judge, I can't force it. But the standard now has become, the expectation is they're going to go to mediation. So I think you're right. It does create the process, and it is a good starting point, because gosh, if you can mediate it and settle it before the next step, whether it be a filing of an arbitration or the filing of a complaint, it's awesome.
Yeah, absolutely. And similarly with the arbitration clause, I want to spell this all out so everybody knows exactly. I like what you said about certainty. We know exactly what's going to happen if
Yep.
we have a dispute. And on that, I know we could talk all day about fee shifting clauses, but pretty much every contract I draft, it has it varies the common law that you would have otherwise, where everybody pays their own legal fees in
Right. The old American rule.
Yeah. So I do the UK rule, the English rule, the loser pays. And I have found over the years, but boy, that will make people think long and hard before they start something.
Yes.
So is that enforceable in arbitration as well?
Yes, it is. And arbitration clauses, again, are contractual. So you can write that contract any way you like for the most part. And you can use the terms for your contract, or you can apply the state law or the federal law that applies. Like under California, you have, Civil Code 1717, which, allows if there's a prevailing party provision, or if it says that one side is to win or receive attorney's fees upon prevailing, it also means the other side's going to win it or get them. So you can write the contract almost any which way you want, and subsequently in an arbitration, the parties could always agree prior to the arbitration subsequently to some form of fee shifting as well. But I just think it's, again, less certain. You best have that in the contract. And I think it's really great if you're writing for companies to have that in there, because before the client files their lawsuit or their arbitration claim, and they understand that there's a prevailing party fee shifting clause, they'll have that conversation with their lawyer. And the lawyer will disclose that and say, our case is weak, let's not file, And those are the kinds of things where I think it really helps to have it all delineated. So when they're thinking of filing, they really have to go through the process, of what the outcomes could be.
Right. So, and that might also aid settlement too, if the stakes are
Yes,
that
I agree.
higher. Now, you said something interesting. The parties can agree on the law. They can even agree where, right? And they can choose.
Oh, yeah. You can agree. The arbitrator will generally pick where, and in generally it's going to be where the arbitration clause, well, it should be where the arbitration clause says it should be. But then sometimes it'll give the arbitrator some discretion as to where and when and etc. But generally the clause should probably set forth the terms of where it's going to be,
Gotcha. All right. So you've been a judge and an arbitrator, so you're probably perfectly poised to answer this. The knock against arbitration, when I explain it to people, they say, well, wait a minute, how do I know that arbitrator is going to follow the law? Because do they have to do that? Because as I understand it, maybe I'm getting ahead of myself, but really, I mean, these decisions are not really reviewable by a court, are they? Or are they?
They can be if both sides agree. You can agree to appealability. You can also put that in the contract terms.
Okay.
I was looking at the appealability, that if there's a clause in the contract, or if the parties agree, you can go, like in JAMS. We have I'm on an appeal right now where the parties agreed to allow it to go to appeal. I would assume you do that before the award, but it is appealable, but mostly not. So there is a finality. So you have to have, you get to pick your arbitrator. That's the other side of it. There's a whole strike process where you can go through and pick your rank and your arbitrator, and then pick that person. You can also put in the contract that it's going to be a retired judge. if you're worried about following the law. And then, I just would say, I think arbitrators, I'd be surprised if you get a rogue arbitrator. I just don't think, you get the rogue arbitrator. Jumping ahead, there might be some equitable relief that they're allowed to use, but being rogue is just not, I think, business savvy and commonsensical. And if you're a judge, you just don't do that. So, you can never give your client complete assurance that, arbitrator isn't going to be whimsical, but I just don't see that happening. And you look at who you're getting and who you're picking. You know what I mean?
Yeah, I know exactly. So as a practical matter, that just doesn't happen that often, I think is what I mean. Okay. And I think what you said earlier, the arbitrators they're bound to follow the law though.
Yes.
Right?
Yes,
okay.
they are.
Okay. Now what you said about equitable relief, and for the audience, it's things like injunctions or restraining orders I don't know about restraining orders, but injunctions. Well, you tell me, what can an arbitrator do?
I think the arbitrator has the same kind of options. First, what you do, as every arbitrator must, is review that contract, review the arbitration clause, look at the parameters that it states in there. What if it does? Sometimes they'll even say the arbitrator has the authority to grant equitable relief. And you can do that. So that's the first step: is look at the contract. Second step is, look at the prayer of the complaint. The prayer, if it's a business litigation and it's just contractual, you're pretty much just going to stick to the four corners of contract law. If there is, specific performance potentiality, that's a form of equitable relief. An arbitrator can do that. That's to order one side, to turn over the tractor to the other side. That's a form of specific performance and equitable relief. When it comes to granting sanctions and monetary awards, for instance, the fee shifting aspect, that's a form of equitable relief as well, and the judge can do that, or the arbitrator can do that. So there is a wide variety of discretion that a judicial officer, I should say, a neutral has in granting the equitable relief. But again, it has to be within the realm of remedy of law. So you can't, you can't order penance. There was a judge in Walnut Creek that made somebody walk to the top of Mount Diablo and back as a penalty. You can't do that. You're going to stay within the parameters of equitable relief in terms of the law. So so you do have a fair number of choices, and a lot of times it's going to be the prayer too. You're looking at that prayer, what the lawyers are asking.
Okay.
And I give one point of advice. When lawyers are filing their arbitration, their arbitrations, keep it. If you want that prevailing party, if you want to be the prevailing party and you have a good case in contract, just file it as a case in contract. Don't throw in the fraud claim, because now you've got another claim. You may lose that. Now who's the prevailing party? You know what I mean?
Yeah, I know what you mean.
Yeah, just file, keep it straightforward, so that the arbitrator says, well, you did breach the contract, you are, you're in violation, but it wasn't fraud. But therefore, the fee shifting is the person won. They're probably going to get their attorney's fees and their costs. But if they threw in the fraud, they may not get those, because now it's sort of 50-50. See what I'm saying?
And the arbitrator has to decide, right?
Yeah, that's just one of those. And the last thing on fee shifting, and this I would also say, is make sure when you're in your arbitration to make your claims before the final award. Once that final award goes out, you can ask for corrections, but you're really not getting a reconsideration. You're getting corrections on the math and maybe other things. But make sure you're asking for what you want and you've laid it all out.
Yeah. It's interesting that you actually read the arbitration clause to find out, I guess, the limits of your authority. And, there's kind of a couple schools of thought. I've seen arbitration clauses and I've had, some lawyers liken it to be just short and sweet, just under the auspices of jams, end of story. And I've seen some that just go on for pages and pages and pages. I mean, do you have a preference as the arbitrator?
Well, I like under the auspices of jams because we have our own rules, so
Yeah,
I know those, when you
yeah,
get stuck reading a 4-page arbitration clause, you're also having to interpret legalese, which can
yeah,
sometimes be, a little convoluted, right?
yeah,
And so simple is not bad. It's just as long as, for instance, venue, arbitrators, equitable relief, um, certain parameters. But um, there's a lot of verbiage that goes into that contract. But if then they say per the rules of jams, well, then the rules of jams are going to prevail,
yeah.
or
Um,
or AAA for that matter.
or,
They've got their own too.
right. So can pretty much any claim be made? It sounds like almost anything could be made subject to arbitration procedure, or at least any business dispute,
Any
right?
business, any contractual employment, anything like that. Not a tort. You can't really, torts are unforeseeable necessarily. No, oh, they're foreseeable potentially. You know what I mean? So you can't really throw those in there.
I get what you mean. But that's interesting about employment because, I know I read enough legal press to know that there's always preemption issues. And the federal government might have a different view on whether employment claims should be arbitrated than the states do. But I think you said earlier that the US Supreme Court is pretty much upheld arbitration clauses, even for employment, right?
Correct. Correct.
Provided the contract. How about waiving the jury part of that? That just goes part and parcel, I
That
suppose.
goes part and parcel with an arbitration.
Right.
If you're a business, I think arbitration makes sense because uh, plaintiffs' lawyers, sort of bank on the volatility of a jury. There's going to be jurors that go beyond the standard deviation of what's expected. And it
Mm,
goes both ways.
yeah.
But there's always those astronomical verdicts that people read about in the paper, and I think that plaintiffs' attorneys might sort of see that as a good bargaining chip to negotiate a better settlement. Whereas you
Yeah.
go to arbitration, and judges tend to find the middle, which is not. Um, if you're a business person, you can then sort of assess what their views are and where the middle is. You know what I mean?
Yeah.
Whereas a jury is just a far less predictable animal,
Yeah.
So,
It just reminds me, I'm from the Midwest. I remember back in the 80s, Jerry Spence had a verdict that was appealed on the basis, and the argument was that he had hypnotized the jury. He was so good.
Jerry
So,
Spitz, yeah, he's a blast from the past. I read one of his books, and he was phenomenal.
well, hopefully you won't get hypnotized by any lawyers. All right. Well, and then the last question I had is, now we get this arbitration award. How do we enforce that? Because this
Well,
is,
it's most of the time the parties. Well, in the jams rules, the parties are deemed to consent to entering the judgment in the court of jurisdiction. So once you get your award and it becomes final, then you can file it in the jurisdiction in which the award was made, or where it's agreed to, and you can execute on it like anything else. I think the Federal Arbitration Act also, is used. So it basically is the same as state law, and you can then just enforce it like a state judgment, like it was, a trial and a judgment entered in court.
okay, good. So you get to the same point.
Yes.
Okay, well, I really want to thank you for being here, Judge. This is really interesting. I certainly learned a lot, and I know that our audience has probably picked up a few points about alternative dispute resolution. This is Roger Royce with the 10,000 Startups podcast. I've been talking with the Honorable Robert Foyles, retired judge who is with JAMS on ADR. And thanks again. We will see you all next
It
week.
was my pleasure. Thank you so much.